and we're going to have a look at the recent push to reform legal costs in Ireland. It's always been a hot topic, but now more so than ever with Brexit and the need to have an efficient legal system that will attract both foreign and domestic investment. It's good to hear, though, that a review group has been established to look at costs and other aspects of civil justice in Ireland today. Could you give us an overview of their work, Sinead, and what they have been looking at in particular?
Yes, so the review group was made up of a number of judges from different court levels, representatives from the Bar Council and the Law Society, and from the court service. So it was a good mix, and they looked at a number of areas. But in terms of legal costs, they looked at how to achieve reductions and made three main recommendations. So non-binding cost guidelines. The second one related to furnishing bills of costs within 3 months of a court making a costs order. And thirdly, it dealt with third-party funding in limited circumstances. So making that available to insolvency practitioners such as liquidators, trustees and administrators in bankruptcy.
So if we look firstly then at the legal costs guidelines, the idea originated in Canada and Australia. And while they won't be binding, by non-binding, we mean that judges will have a discretion in following them. The hope is that this will assist parties and their legal representatives by reference to a table of individual legal actions, which will then have a corresponding legal cost. But is there a downside to this proposal, Sinead?
Well, the review group couldn't reach consensus on the issue, so the majority favoured non-binding legal guidelines, while the minority wanted, fixed, prescribed cost levels. So it remains to be seen whether it'll have much of an impact in practice, given the fact that they're non-binding.
Okay then, so after guidelines, the second limb of proposed reform was in relation to bills of costs. So the review group, as you mentioned, recommended a 3-month time limit from the court order awarding a party their costs within which to furnish a bill of costs. Can you tell us a bit more about that proposal?
Yes, so the introduction of this time limit, together with any penalties for non-compliance, will require amendment to legislation. But it could be a simple but very effective step at bringing more finality for clients and for the other parties to litigation, because cost issues in litigation can often linger long after proceedings have finished.
So the third area then of reform is in relation to third-party funding. Now, this has always been topical in Ireland because currently this is not permitted as a result of age-old laws prohibiting champerty and maintenance. So as a reminder for people, maintenance is the funding of litigation in which the funder has no interest, and champerty is the funding of litigation in exchange for a share of the proceeds of that litigation. These remain criminal offences and civil wrongs in Ireland, but I see that the review group has recommended permitting third-party funding for, again, as you mentioned, liquidators, receivers, administrators, the official assignee or trustees in bankruptcy to fund certain types of proceedings. What is your view on that?
So this mechanism, if introduced, will be welcome news for creditors. The review group looked at permitting third-party funding in limited circumstances for those insolvency practitioners. If they have an arguably good case, but they don't have the funding to bring it, then it could permit them to bring the case. And if they're successful, then increase the pool of assets available to creditors. So it's welcome, but it's slightly disappointing that the group didn't go so far as to expand out litigation or third-party funding in line with the UK, where it's much wider. But they did confine it because our own Law Reform Commission is due to publish a report on third-party funding as a whole. So we'll watch this space.
So to conclude then, the recommendations should generally be welcome news for individuals and companies doing business in Ireland. The cost of litigation often influences the cost of doing business, but also the prices of goods and services. Internationally, the cost of high litigation could be seen to impact the strength of the rule of law in this jurisdiction, but also, and I think more importantly, our capacity to attract domestic and foreign investment.
Yes, so the real work will lie in transposing the recommendations from paper into practice. our Justice Minister, Helen McEntee, has openly committed already in her Justice Plan for this year to review the recommendations in detail in the report, particularly in relation to costs. And it has even gone so far as to mention introducing legal cost scales or fixed guidelines, which would be binding except where the parties opt out. So that goes further than the reports. So her department is due to finish its review by the end of Q4. So we'll wait to see what comes out of that. Thank you very much for listening to us today. If you wish to see any other videos, please subscribe to our YouTube channel. And if you'd like any more information on the review group's work on the administration of justice in Ireland, please check out our website.